Hello and welcome to MySecurity TV and our Tech and Sec Weekly. Today we're diving into RegTech or Regulation Technology, which is going to be joined by Liam Hennessy, the director with Gadens, the law firm. He's based in Queensland, but it's a national law firm, and they've released a BreachManager reporting platform for cybersecurity breaches, particularly for their clients as well. So it's interesting technology. We'll see how they're going to apply it as well. So we'll be joined by Liam first up. We cover off on RegTech and BreachManager with Liam Hennessy. They're in Brisbane. Liam, thanks for joining us.
Thanks for having me, Chris. Happy to be here.
Very good. Director with Gadens, a national law firm. Is it just Australia or is it international Gadens? Pretty large?
Just a national law firm.
Okay, so Australian law firm. Now,
with a large range of affiliates around the world.
Basically, you don't say no to a new client. In other words, doesn't matter where they are if they need to be represented. So this is really into. I don't think we've covered a lot on RegTech or RegTech, however you want to say it. Introduce us to BreachManager. It's good to see a law firm, one, being innovative. All companies now are digital companies. And the background to this, and we'll also cover off a little bit on the regulation environment and notifiable data breach legislation here in Australia, and the background. So introduce us to BreachManager, and then we'll sort of talk about the platform.
Yeah, wonderful. Okay, I plan to share my screen.
Okay. Yep. Here we go.
Wonderful. So. The essential concept behind the BreachManager is that it's designed for financial services institutions, so that's banks, that's super firms, that's insurers, all of which are subject to some really heavy regulation from ASIC, APRA, AUSTRAC, and the Privacy Commissioner. There's going to be about 7 different overlapping regimes as of October this year for those entities. And each one of them requires those firms to report if there has been a particular issue that falls within those regulatory frameworks. So, for example, if there has been a cyber attack where a large amount of customer data has been exposed to bad actors, then the financial, let's pick a bank, for example, then the bank will have to report that to the Office of the Information Commissioner. May also be, depending on how serious it is and what vulnerabilities were exploited, a matter to report to ASIC, the corporate regulator, or indeed APRA as the prudential regulator. I think what's critical about these regimes is that they overlap. There is a lot of interpretation applied to them. So, one of them is you must act with integrity and honesty. You must act, and there's a lot of different interpretations around integrity and honesty. I guess due care, skill, and diligence is another one, which people will bring different interpretations to. That level of interpretation, combined with the fact that this has to be done within really quick timeframes, 24 hours for terrorism, suspicions, 72 hours for anti-money laundering, 10 days for cyber attacks under an AFSL license, makes this a real pressure point for our financial institutions.
So just to clarify on what it does cover, it's not just on cyber-related breaches, it's a regulation breach on its own?
Yeah, indeed. It'll cover the full gamut of regulatory breaches. That may be internal fraud in your trading department.
Right.
That may be a cyber attack over in your, in one of your retail customer line segments. That may be any money laundering sort of concerns. You've got a whole lot of suspicious transactions which have slipped through the net. It covers, the goal of the system is to create an online platform that will house all of the information according to those systems. And it's structured a bit like a BuzzFeed article. So the users will go through and they will, for each of the 7 different regimes I've mentioned, click on what they think the issue may trigger. So for a cyber attack, for example, they'll start with an AFSL regime and say, look, gee whiz, I think that this does breach our licence obligation to act honestly and fairly, they'll then move down and there'll be a free type box, and that box will be populated with exactly what information the regulator would expect to see. So very quick, will take them about 5 or 6 minutes. Things like frequency, things like customers that have been harmed, things like how the vulnerability was exploited. Second box, upload all of your information. Now, typically these breaches happen at 3:30 p.m. on a Friday afternoon. So it's really tough for in-house legal counsel under sort of time pressure to exercise their judgment on what is a huge volume of information. You upload it to the portal, and then that's the AFSL regime done. Move on to AUSTRAC's regime, the anti-money laundering one. Same process, click a few buttons which you think that the issue corresponds to, whether that's fraud, whether that's terrorism financing, whether that's money laundering. Right in the box the things that AUSTRAC would want to see, which we have as a law firm already put in there. So we've guided people to tell us the information we want. You don't need to go to the regulatory guides, you don't need to go to the legislation, you don't need to look up stuff. It's all in this system. Attach the documents. By the time you get to the end of this, and we've timed ourselves, and it will take about 20 to 30 minutes depending on how complex things are, what you will have is an online application that's protected from a cyber perspective, that's protected from a legal privilege perspective, that's protected from a server perspective, and is ready to be allocated to someone. Now, if I'm a big bank and I'm the gatekeeper of this system, I can allocate this issue internally for someone to determine whether this is a significant breach or not, and they can apply their legal judgment and acumen to determining whether this is something that needs to be reported to ASIC or AUSTRAC or the Information Commissioner, with all the associated consequences of that. I should say these are big decisions. Some of them affect people's personal liability, and that will be free of charge. You just pay the platform cost, which is I think $500 a week. So we've really designed this to help our clients out, and there's 10,000 plus people with a financial services license or credit license or bank license in Australia. So we're talking about a large portion of the market that is very vulnerable to cyber attacks, cyber breaches and so forth that we're trying to protect, and this will be theirs free of charge if they want it.
So this is again for the law firm to fill out, or the legal representation to fill out?
No, this is for the internal people to fill out.
Okay, so this is for the company and the client perspective. And how is the breach triggered? Is it there are other processes and they're going, okay, we've got a potential breach of some regulation here. We have to go down to BreachManager and start to fill out those details. Is that how it's going to work? And then that gets submitted back to the law firm?
Yeah, so, I mean, an issue will arise, and that issue can be one of a number of different things. You know, we've overcharged our customers, we've had a cyber attack, we think there's been some fraud, we think we've breached some regulations here. You then take that information, that inkling, and you put it into the BreachManager, and then you've got a system which will allow someone at the end, it can either be the bank's internal legal counsel, or it can be Gadens, to tell you, you don't have a breach, and here's a legal advice saying that you don't have one, and if a regulator ever comes along and interrogates that, you can wave that around. Number two, you do have a breach, and we've prepared the breach report for you, and you can submit that to ASIC AUSTRAC. Or number three, you know what, this is really complicated stuff, we think we need a bit more information, here's exactly what you want to look for. And from the Gadens side, we only ever expect, you know, we're happy to provide this system for our clients without legal costs. They'll just pay for the platform and the authorizations. If they do decide to get us to do that advice for them, we'll charge them a relatively low fixed fee, because in my experience over the last 15 years, with legal spend, sometimes that can balloon out when you're trying to get to grips with what an issue is. So we thought that charging clients $14.50 for that advice and that breach report, if indeed it is a breach report, would allow general counsels, heads of compliance to say, do you know what, I've got someone who's handling this, I've got control of my legal spend, it's okay.
Now, what is the plan with this? This has been live for about 3 days. It sounds like it's a bit of a sort of an online form, an online guide. And is there any smarts built into this? What if legislation changes, updates from the regulators, that changes the information? And also, potentially, is anyone else making a similar report, particularly if it's a cyber breach, how you might match that to other types of reports as well? Yeah, how much smarts is in this, or what's the roadmap for it?
Yeah, I mean, it's really good questions. In terms of the smarts in this, one of the important thing is, the time frames. If you report a breach outside the 10-day time frame, you can be up for very large, millions of dollars of fines. So I guess the first piece of tech in here is the fact that it's completely auditable. It'll send text messages out if we're counting down the time to the lawyers, the internal people. It'll be able to be interrogated after the fact. In terms of the legislation and law changes, that's on Gadens. This system is going to be 100% up to date with the law. And we will, because this is our name, this is our brand here, we'll make sure whoever jumps into this system is at the cutting edge of regulatory practice. In October of this year, ASIC's overhauling its breach reporting regime. So we will be updating this system then in order to respond to those legislative changes.
Have you had any comments or feedback from the regulators as well?
No official comment. I haven't. Look, I think without naming names, the feedback that we've had is anything that helps the regulated population to identify breaches and to transmit that through to the regulator in a format that they want to see is a good thing for them. We'll be preparing, when we're asked to, these breach reports in a way that, the regulator can say, you've really thought about this, you've really given me what I need. And they're appreciative of that.
And can you submit it sort of halfway through? As you say, you've got a time frame there, like a notifiable data breach, you've got 72 hours, but you might be still investigating what is going on, so you can sort of fill out half of the form and at least submit that, not just to the law firm, but start to feed that information through in a consistent way and build almost like a living document that gets built up over time. Is that a tool that it can be used for as well?
Yes, indeed. I mean, this is a wonderful, I don't want to use the term black box, but this is protected from our cyber, from a privilege point of view, because ultimately you're putting information in here for a legal assessment. And you'll be then able to take out what further information gets transmitted back and forth through here to update the regulators later on if you need to do that. I mentioned the changes coming in October of this year. One of the differences that's going to generate is that you have to not only notify if you do have a significant breach, you have to notify when you start an investigation. So
yeah, right, exactly, yeah.
We're going to build that functionality in. So
is there any interest from the regulators to have access to it? Is that a possible, although you've got the gap between legal professional privilege and what the regulators will want to know, and I take it once they use this platform, LLP applies straight away anyway, correct? So they are protected in what they start putting in.
Indeed it does, and that's really important. I mean, and privilege is a fundamental right of all clients. So, and you have to be able to have those open and frank discussions with your lawyers and to, take the different legal views on things and, have robust discussions about, whether it does meet the threshold. I mentioned before that one of the mandatory reporting thresholds is predicated on the word integrity. Now, say you, Chris, are accountable people, the senior executives of the bank who are personally liable have to act in integrity in their day-to-day. Say you're the head of tech at one of the big banks and you're a wonderful executive at one of the big banks and you perform your role in a stellar fashion. However, you cheat on your public transport fares and you never pay anything using the Sydney train station and you rack up a $20,000 debt at Wynyard. I'm not suggesting you do this, but For
I've only had
argument's
a
sake,
caution. That's all.
for argument's sake, is that a breach of integrity such that we should report it to the regulators? Now, there'll be differing views on that. Some people will say, well, no, hold on, this isn't part of your day job. Other people will say, well, integrity goes beyond your day job. It's those types of discussions that, you know, we need to have openly and frankly behind, you know, privilege, and then whatever the outworking of it is goes to the regulator or not, as the case may be.
Yeah, look, from a compliance, governance and integrity viewpoint, I can definitely see the advantages of this. And I think directors need to be pretty careful as well, because once that form starts to get filled out, it's a bit of a timestamp on the knowledge of whether an investigation started or a breach has occurred. So you better not be off selling shares after that. If it's that type of circumstance as well, they've got to be a bit careful on what's being provided, despite the legal professional privilege. But again, it's an electronic document, so there's still going to be some records like the metadata of that falls into LLP. What's your opinion on that, just out of interest, of the metadata of access to the site itself? Is that LLP?
LLP, yes. That would certainly be.
So you can't even.
Covered.
So even the log that someone accessed the site would be legal professional privilege? Well, you guys would argue that anyway, wouldn't you?
Yes.
Yeah. Fair call. Well, look, it's an interesting one. We've got our next guest available, so we'll hang on. But just one last question, and I did cover it with you, is the activity, the background, sort of the driver of this. You mentioned sort of October this year, we're going to have a bit of a mishmash on regulations. It's a tough regulatory environment for business, and it's only going to get tougher. And you know, the regulators have been a bit behind recently in a whole range of different industries. So the next couple of years might well be a heightened state of regulation or regulation control, and we might get some insights from Ron on that as well coming up next from the industry perspective. But what was the background on this that was driving it? Was a client driving this, of clients missing the notifications and not quite understanding it, but also from the law firm saying, I think we can do things better to make it easy for the clients, as well as this sort of wave of regulation coming? Kind of what was the major driver on this?
Yeah, and it's a fantastic question. Look, in 2018, in the middle of the Hayne Royal Commission, ASIC released a report that said the major four banks were on average about 150 days in reporting breaches. The requirement is 10 days. Since then, more mandatory reporting regimes, there's been fines attached to these things, and we had some pretty concerned clients. So here at Gadens, you know, we pride ourselves a lot on sort of legal innovation and tech, and we really worked hard over about 6 months to figure how we could add value to our clients in this space. And working with them, you know, in various different fashions, this was the outworking of it, something that would help them to meet, you know, these complex, you know, interpretationally challenging sort of mandatory reporting regimes within the timeframes. So yeah, I'm really excited that the rubber's hit the road on it.
Yeah. Well, look, a couple comes to mind. One is Data 61. We're working on a regulation AI tool on how regulation comes together. So I can see some potential segues there. And I mentioned 6 Clicks that we spoke to last week that have an AI tool as well that keep up with regulations and changes in standards and a range of different things. And I think other than just using this as a tool for Gadens and Gaden clients, I can see a potential wider market application for this. So I think, you know, well done. We don't speak to many lawyers with a technology innovation, so well done, and well done to Gadens. So good on you.
Thank you very much. Thanks for having me.
Good on you, Liam. We'll let you go, and we'll cross over to Ron. So thanks, Liam. Liam Hennessy, Director with Gadens up there in Queensland. It's a national law firm and operating as Lavens over in WA. Thanks, Liam. Have a good day.
You too.
Cheers, mate. Bye-bye.